AI is a powerful tool.
This summit can help ensure that artificial intelligence charts a course that benefits humanity and bolsters our shared values.
Welcome to AI for Good, the leading action-oriented, global and inclusive United Nations platform on AI. Organized by ITU, in partnership with 40 UN sister organizations, and co-convened with Switzerland. The goal of AI for Good is to identify practical applications of AI to advance the United Nations Sustainable Development Goals and scale those solutions for global impact. In today's session, we're counting on you to use the live video wall feature to ask questions and post comments to help create an engaging discussion. We encourage you to stay until the end to chat, connect, ask questions, and network with our distinguished panelists and world-class AI experts in the neural network. It is now time to kick off the session and welcome our first speaker. The floor is yours.
Hello, and good afternoon, Berlin. Good morning to the US East Coast, and very warm welcome to the audience all around the world from AI for Good. We are here at AI Campus Berlin, Merantix AI Campus, and I'm Philipp. I'm professor for law and technology at European New School Viadrina, European University Viadrina near Berlin in Frankfurt-Oder. I'm an expert. I do a lot of research on AI regulation and also on AI liability, and that's precisely the topic of today's discussion. So we have convened an interdisciplinary international panel to look at some of the most timely questions we have when it comes to AI, because we all know that AI harbors great potential, but at the same time, it's of course not free from error. Teslas keep, crashing into buildings and other cars. Generative AI tools have just apparently contributed, at least to some extent, to the suicide of a man in Belgium. And in all these cases, of course, the question arises, who's responsible for it and who's going to pay in legal terms? So to answer these questions, we have a great lineup of speakers with us online and here in Berlin. We have online with us Joe Gugliardo. He is a leading technology lawyer from the US who joins us just from New York City. He is a partner at Dentons and advises clients, big corporations and smaller ones, in all matters concerning tech law, but particularly with a focus on AI. We'll have larger introductions when we go through the individual talks, but right next to me, we have somebody who I don't have to present to the audience in Berlin, but maybe to the others on the worldwide stage. So this is Rasmus Rothe. He co-founded Merantix, and he is also a co-founder of the very AI campus we're located at. Maybe you can just say a few words of welcome concerning the campus.
Yeah, sure. Thanks, Philipp, for the introductions, and welcome to the AI campus here. We started this project here 2 years ago, really with the goal of bringing the AI community together in Germany and Berlin. And by now, basically, there is more than 90 companies, 600 people here working from the AI companies. And the idea is really to have exactly this discussions like today, different stakeholders, not just startups, not just corporates, not just investors, not just researchers, not just policymakers individually, discussing AI, but basically bringing them together and having a joint discussion. And I think the AI liability topic is a big one, and so very much looking forward to today.
Also, welcome from my side. So I'm Wojciech Samek, head of AI at Fraunhofer HHI and professor for machine learning at Technical University of Berlin. I'm also very happy to participate here and to look forward to this exciting discussion.
Thanks. So the way we're going to handle this is that we will have short, about 10-minute input statements by each of the panelists. I'll start out with a European perspective on AI liability, and then Joe will take over for an US/international perspective on AI liability, both from a rather legal point of view. Then we'll have a 10-minute Q&A session to discuss the first questions that have popped up and that are urgent enough to be asked. And then we'll go for the second round of input statements by Rasmus, bringing in an industry perspective, and then by Wojciech, bringing in an AI research perspective. And at the very end, we'll have like 20 to 30 minutes, depending on how fast everything goes, for a larger Q&A. And of course, we'll bring in questions from the chat, from online, but also hear from the audience in Berlin. Okay, so let's get started. Maybe I'm just going to share my screen for a very gentle introduction. I hope you can see it on AI liability in Europe and what is happening right now at the heart of the European Commission and the European Parliament. So you probably all know that that we have a complex topic ahead of us, and I want to try to approach it in 3 gentle steps. So first, just tell you a little bit about the current EU framework. What is the law really that is already applicable to AI systems when it comes to preventing and suing for damage for accidents? The second part, again, very briefly, will touch upon the new proposals. I call it the AI liability package that was unveiled by the EU Commission in September 2022, and also just briefly looking at a glance at the AI Act and everything that pertains to liability in this new instrument that is being hotly debated, of course, right now at the European Parliament. And then the third step, I just want to shed some light on the question of how does liability look like when we think of generative AI. So ChatGPT, GPT-4 part, all of these things, things that developers around the world are integrating into their products without necessarily knowing what the consequence for them will be from a liability perspective. Of course, I could talk about this for ages, so I'll try to put all of this in 10 minutes. Here are 2 papers that I've recently written on AI liability directives and also on regulating large generative AI models, where everything is spelled out in much greater detail. Okay, so let's get started here. And I just want to put everybody on the same page using kind of a lead example, because we all know that if there's one kind of category where we think about liability, it's probably car crashes, right? Cars crash all the time, and not only normal cars, but also autonomous vehicles. We do know that there have been several incidents of fatal accidents now involving Tesla's autopilot, and then the question becomes, who is going to pay for this and who is liable? All right, so in the EU, this matter, unfortunately, is a little complex, as in many other jurisdictions, I suppose, but particularly here. Why this? In the EU, we have kind of 2, let's say, 2 dimensions of product regulation. And the product in this case is the car, and there are several components to it, and the AI would be one component to this car product. So the first pillar, let's say, is product safety. Product safety regulation that says what a car has to do, what kind of requirements it has to fulfill to be able to and to be allowed to drive on a road. And of course, we have that in the US and in all other, most other countries, I suspect. And then the second question is, who is going to be liable if the car crashes? And this question is answered in a second pillar in EU law that's called product liability. And the 2 are somewhat connected, but they're not perfectly interwoven, and particularly not when it comes to AI. So concerning traditional products, you can see that there are specific regulations for many different product categories, such as toys, for example, how to manufacture toys, and cars, how to go about manufacturing cars so that they're safe. On the other hand, we have then a whole corpus of product liability laws, and most importantly, it is necessary to distinguish between member state law and EU law. We won't go into the details here, but long story short, there has always been, since the probably 1950s, 60s, in member states like Germany, France, Spain, a specific law governing product errors, product accidents, because it's a general topic, of course, that comes up a lot. And that is dealt with in a specific section of the law of torts. In Germany, it's Produkthaftungsgesetz, would be the Product Liability Act. But the problem with this is that in fact, of course, the EU saw that this is a problem that arises everywhere in the member states. And therefore, in 1985, they passed what's called the Product Liability Directive. And the Product Liability Directive is kind of the EU law that governs all of this. And this EU law setting, and I'm sorry, I just mispronounced what we have in Germany, this is what then is transposed in member states. And this, in fact, is what constitutes in Germany the Product Liability Act. And we have different legislation in Germany that's member state legislation. And that's the same for all of the different countries. And that makes it highly complicated. We have this EU law layer, and we have this member state layer. And to be liable, it's enough that either the EU law or the member state law says that you're liable. So conversely, if you want to avoid liability as a developer, you have to comply both with the EU law system and the member state law system. Okay, so this is for starters. Now, how does this change with the proposed AI Act and the liability package? Let's go back to our chart here. And we can see that when it comes to AI products, there is now product safety regulation that is considered, and that is basically the AI Act. The AI Act that everybody's talking about in Europe at the moment is a sub-feature, let's say subcategory of product safety regulation. It has specific rules, as you know, for data governance, for oversight, and you name it, for transparency. And if you breach those, it does not exactly say who's going to be liable. It says that there might be fees, administrative fees, but it does not say who's liable. However, it has different risk categories. And I would say almost funny, but it's not really funny, it's rather tragic fact is that it has different categories for toys and for autonomous vehicles. And now please raise your hand if you think that toys are high risk. So there's high risk categories and not high risk categories. Raise your hand if you think that toys are high risk. Well, there's two persons who kind of timidly think that's the case, and maybe some in the audience. Raise your hands, please, if you think that autonomous vehicles are high risk. They should be high risk products. Well, I guess all the hands go up. As you can imagine from the way I asked this question, it's just the inverse. So under the current version of the AI Act, and this is truly crazy, and I can tell you in the discussion a little more about it, toys are considered high risk, but autonomous vehicles are not. It's a little bit obscure, and it's obviously totally nonsensical. But that's just the way it is. And then when we want to know who is going to be the responsible in the end, who's liable, we have to look at what the Commission published in September 2022, in which it's taken forward as the AI Liability Package. So we have two of these funny abbreviations. We have the AI Liability Directive, and this is a directive that will look at, I'll take your question in a sec, that will look at member state law, and that will try to harmonize procedural parts of member state law. However, because member states are not happy that the EU Commission, again, is interfering in what they perceive as their autonomous law, this is now stalled. So it's unlikely whether this is ever going to be enacted. So we'll leave this aside for a second, and we'll just focus on the PLD proposal. So it's an amendment to the Product Liability Directive, EU law, and this is crucial in bringing about or spelling out the regime for AI liability, because it will extend the liability that now covers traditional products, toys, cars, to any kind of software, including AI. Okay, so what's the relationship, we might then ask, between the AI Act and these different directives? Well, so far, so bad. There is some clear-cut connection between the AI Act and the liability directive, which, as I said, is stalled. So we just keep it out of the window. We bracket it for the moment. There is no clear-cut connection between the AI Act and the product liability directive. In my view, that's, again, nonsensical. Of course, there should be an interconnection. I've written a little bit about it in my longer paper. Long story short, of course, would be if you breach the AI Act, then to some extent you should also be liable. And if you don't breach the AI Act, well, then probably you also shouldn't be liable. Okay, so that's the general idea. And we take it forward from here just a little bit to ask what this actually means in a concrete case. So if we think about cars, for example, autonomous vehicle accidents, we have to say that the product liability directive, this update, it will apply, and this is actually proceeding as planned. So it's in the Council of the European Union right now, and I'm pretty sure that this will become the law when the AI Act kicks in. So probably middle of 2025. From then on, this is going to be very likely the law in the EU. So we have now liability, as I said, for software. Well, we're going to have it just like for traditional products. And why is this different? Well, first of all, it was unclear to this date whether software is covered at all by product liability law. But the important thing is that we have now then a regime in place which says consumers can sue the producer, that is the developers, if there is a mistake in the software, if there is a defect. The law says defect. And then the question, of course, is, well, what is a defect and how in the world is this consumer supposed to know that there was a defect? Consumer that doesn't write or read code or anything. So the EU Commission came up with these two ideas. First one is disclosure of evidence. If you're from the US, like Joe is, or if you've had any exposure to US legal system, you might think of you might know what's called pre-trial discovery proceedings. And Joe can tell you more about it maybe, but basically the idea is, and this is what they try to copy sort of here in the EU, if somebody thinks that they have a claim against you, say, the car crashed and you got hurt because the Tesla ran into you and didn't recognize you apparently as a person, then you need to have a plausible claim. You need to submit evidence that it's plausible that you have a claim because there was a defect. And if you can say that it's plausible, then you can access a lot of material, the evidence from the developers to actually then look at it with the help of an AI expert and to prove that, well, this is actually something that constitutes an error, a defect of the car. That's the first thing. So you get the information because without the data and the model, or without access to some parts of it, of course, as a victim, you're lost. Second thing is, and that's really of massive importance for companies and startups, there is a presumption of defectiveness. In some cases, particularly if there was an obvious product malfunction, and if a car, runs right into you, despite the fact that, you didn't jump into the street, but rather you say you cross the street normally and the car still runs into you or your car or whatever, then that might be considered a case of an obvious product malfunction. So the example that the Commission gives is a glass bottle that just explodes in your hand, or like a glass like this just crumbles in your hand. That would be an obvious product malfunction. So there's going to be a lot of debate about what constitutes an obvious AI product malfunction, but I guess these cases should be obvious enough, like running into somebody who's not making any mistake. So that would trigger a presumption of defectiveness, and that means that a startup or the company, they need then to show that there was no defect. Okay, so it reverses the burden of proof. And even outside of obvious product malfunctions, there is another case, and I call it the three-factor test. If it's excessively difficult for the claimant, so for the victim, because of technical or scientific complexity of the product, and one case that is explicitly mentioned in the directive is machine learning. So the Commission says machine learning is always excessively difficult, probably not true. If it's like a linear regression, it's not excessively difficult, but okay, let's put this aside. So most cases of machine learning, this is going to apply. Then the victim only has to show that the product likely caused the damage. And then again, there is this presumption. And I mean, so to show that if the car runs into you, that it likely caused the damage, yes, of course. So then in many cases, machine learning, actually, we're going to have this reversal of the burden of proof, meaning that the company, startup, the developers, they have to show that they did nothing wrong. So they have to log a lot, and they have to document a lot, and they have to hire good lawyers. Good news for Joe, I guess, perhaps not so good for the startup scene. Let's see. Okay, so this is just an overview, and I'm already over time, so we can have a look at this later on. I just want to finish with just 2 thoughts on liability for generative AI, because this is something that people might be interested in also. What's important to know is that the Court of Justice of the European Union has recently ruled conclusively that information is not a product. It was about a newspaper article, and the newspaper article was somewhat badly written or whatever. There was wrong information in it, and that caused some harm. And the CJU said, well, the content of this newspaper is not a product. It's the newspaper itself, that's a product, but not the content. And again, here we would have to say, I guess, well, the AI, generative AI system, that is a product, but not the output. So if the output is wrong or fake or discriminating or whatever, it's not a case of product liability. So whatever I told you before about product liability, this does not apply to generative AI. Rather, it's a totally different set of regulations again, and that is speech regulation, which is rather tough, of course. In some countries of the EU, like Germany, it's rather lightweight or very different, at least in the US, and Joe might say something about it. So here we have some things that restrict free speech. Let's say if you engage in libel, if you utter threats, if you have other illegal content, like in Germany, of course, Holocaust denial is prohibited. Swastika is a prohibited symbol. If there is speech that results in bodily or mental harm, and think about the Belgian case, like we could discuss whether, if this chatbot really induced suicide, if there is something to be said about potential liability of the developers here. And the question becomes, who is liable? And just to finish, I want to say there's direct liability potentially of the developers. So OpenAI, or in the Belgian case, it wasn't OpenAI, it was GPTJ, I think a Californian startup, for the harmful speech. That is possible because in the US, we have a Section 230. In Europe, we have a similar thing, a liability field. If you're only hosting stuff, if you're only reproducing what others write, like Facebook or Twitter or so, but that likely doesn't apply to generative AI. I'm happy to take a question on this. And then, of course, the question is, if you're a deployer, if you're a user, are you going to be liable for what ChatGPT or GPT-4 or other programs do and produce as output? And there, the answer would be, short answer would be yes, if you adopt it as your own point of view. So if you only share to say, hey, look, I'm a researcher, or I just want to comment on this, this is the nonsensical stuff that, ChatGPT output, and you put this online, making clear that it's not your view, then you're very likely not liable. But if you just share this, you perhaps don't even say it was generated by ChatGPT, but you just share it, then yes, you're liable. Again, if it falls under any of these categories of kind of illegal content like libel, threats, and so on, or speech that results in bodily or mental harm. And there's, of course, a lot of open questions. You might have heard that Italy just on Friday banned ChatGPT for data protection reasons. There's lots of questions here. Happy to take more questions in the discussion. Time is up, so I just want to say, how can we go forward? I think we need an AI regime that does address risks in an adequate way, but that does not, on the other hand, unduly hamper innovation. Our long-term goal should be that AI liability aligns perfectly with the AI Act so that regulators, stakeholders, and developers, of course, don't have to comply with 2 different sets of standards, but only one, the AI Act, not a different one for liability. And I think we also need safe harbors for users and developers to know when they're good to go, when they're kind of safe from liability, and when they're at their own risk. So that's just all I'm going to say here. I'll leave the conclusions for myself, and I'm happy to pass over to Joe, and then we'll take the first round of questions after that. So Joe, as I said, is a technology law expert, and I think he will say just a little bit more about what he's doing, and I'm very much looking forward to his presentation from a US point of view. Thanks, Joe.
Great, thank you. Thanks for the introduction, and thank you for having me. I'm Joe Gualiardo. As I mentioned, a partner and technology lawyer at Dentons. As a tech lawyer, I help clients bring technology to market that includes counseling on go-to-market commercial transactions, intellectual property matters, and of course, navigating the intersection of tech, regulatory, and policy matters. I'm not a products liability lawyer or a litigator, but of course, in representing tech companies, we need to be thinking about that all the time in terms of go-to-market strategy, commercial agreements, and certainly our end customers. Just by way of very quick background about Dentons, the largest law firm in the world with offices in over 80 countries. We're very active globally, representing a wide range of tech clients, including AI, AV, and Web3 companies. As a tech veteran of 30 years, I'm passionate about these topics and of course have some strong opinions about the intersection of law and technology. Opinions expressed today are mine and not Dentons. I'm going to make some remarks today about the state of policy and law in the US around AI generally, some specifics on autonomous vehicles, and then a light touch on tangentially related blockchain and Web3, because I think there's some similar themes that are worth discussing. So let me start by saying what is obvious perhaps to many. We're in a period of unprecedented tech innovation, perhaps some of the most disruptive innovation in many generations, AI, AV, blockchain, Web3. But what is less obvious, I think, and critical to keep front and center is that this is not the first time in history we're confronted with disruptive technology. It's natural to be skeptical and even fearful of it. However, lawyers, lawmakers, policymakers, founders, academics, we can't allow that fear of unknown to stifle innovation for an entire tech movement. And so my strong message, and I think we heard it in the earlier presentation, that finding the right balance of good and responsible policy and lawmaking without stifling innovation is critical. It's not just about lawmakers, though. Founders and developers have an important role to develop responsibly, and most importantly, educate lawmakers and to collaborate. So with that, let me turn to the US. US is in a good position to find that right balance. Why? Because we still don't have a comprehensive federal framework for AI, AV, or Web3. And some have criticized, certainly stateside, the US for falling behind, but I'm not so sure about this. We have an opportunity in the US to be very deliberate in our approach. If we can get past partisan interests here in the US and work closely with the EU and other international lawmakers. So where do we stand in the US? So by way of high-level background, US laws are established at the federal, state level, and local level. This means there can be overarching federal law, and then individual states would also have their own laws governing certain activity. So it's not uncommon, particularly in early tech innovation, that initial laws are patchwork, namely there's no federal framework in some early adopter states. That's certainly the current situation in AI and AV, no federal overarching framework, some state level efforts to regulate this. Despite it, there's strong lobbying by the US Chamber of Commerce, industry groups, and some vocal congresspersons to establish a federal regulatory framework. And we do have some progress. We've seen activity in the US really on 3 different levels. Some proposed bills at the federal and state level for new law, the application of existing laws to AI and AV, for example, fair lending laws, and of course, privacy. The first 2, of course, are, and of course, the guidance from regulatory bodies, which we'll talk about in just a minute. The first 2 are hard laws. The third, which is guidance, is more sort of soft law, but nonetheless, they establish and have established principles and guidelines for best practices, and really do have an influence on where we see the laws headed. So let's talk briefly about the AI Initiative Act and some of the proposed legislation. The National AI Initiative Act of 2020 became law in 2021. It's not an overarching AI law, but rather it does provide a coordinated program across federal government to accelerate AI research and development. The mission is really to ensure the US's continued leadership in AI and research and to prepare for the future. So in many respects, it's an enabling act and does show that the US is making progress and, of course, taking this seriously. It establishes an important framework to strengthen and coordinate not just US departments and agencies, but very importantly, in cooperation with academia, industry, nonprofits, and civil organizations. In addition, we have seen some proposed law by Congress, none of which has been actually signed in law, but it's definitely instructive in terms of where we're headed. The Algorithmic Accountability Act draws from GDPR, reporting obligations and requirements for business to conduct impact assessment for bias, effectiveness, and other factors. The American Data Privacy and Protection Act establishes requirements for how companies handle personal data. The Platform Accountability and Transparency Act is a bill that would require social media companies to provide vetted independent researchers and the public with access to certain platform data. And the Fake Force Act legislation, which would create a task force charged with producing a coordinated plan to explore digital content provenance standard and how it can assist in reducing spread of deep fakes. So let's talk about existing laws. We have seen the application of existing laws, most commonly in the area of privacy and anti-discrimination. For example, with respect to credit and anti-discrimination, regulators in the US have reminded companies that laws such as the Fair Credit Reporting Act and Equal Credit Opportunity Act, which addresses requirements for accuracy and fairness in credit reporting and anti-discrimination in credit underwriting, do apply to AI. The guidance from US regulators establishes that federal consumer protection laws should be enforced regardless of the technology used by creditors, and creditors cannot justify non-compliance based on the fact that technology that they use is too complicated or new. Again, a theme that I think is very important in how US regulators are looking at this new technology. The Federal Trade Commission, which enforces these important laws, protecting against unfair trade practices, emphasizes the importance of using AI truthfully, fairly, and equitably. We've seen also civil rights laws in the US applied to AI, again, applying existing laws and individual rights to this emerging technology with the theme of fairness and anti-discrimination. With respect to guidance, and this is important because it really does show sort of the way the US is thinking about where the laws are going. Last year, the White House published the Blueprint for AI Bill of Rights, which focuses on the responsible development of safe and effective AI systems. And the proposal notes that, again, these are themes that the public should be protected from unsafe and ineffective systems through the use of extensive testing. The public should not face discrimination by algorithms within systems. The public should be protected from abusive practices through the implementation of other protections built into the AI algorithms. The public should know that automated system is being used and understand how and why it contributes to outcomes and how it impacts them. And of course, the ability to opt out of automated systems. So on both the federal and state levels, the guidance really is around five, but four main pillars. And that is fairness, explainability, transparency, and accountability. With respect to fairness in AI systems, they need to be free of bias, whether intentional or unintentional. Explainability really means, at the end of the day, companies and innovators need to be able to explain this technology in technical terms for general public to understand. Transparency calls for companies to be open about how their AI technology works. And accountability and audibility principle is reflected in the call for companies to continuously inspect their AI technologies for bugs and biases. And then ultimately, the fifth sort of overarching pillar is responsibility, that within an organization, if you're a founder, or a CEO. There has to be someone responsible within the organization to own these pillars. Last January, the U.S. National Institute of Standards and Technology, NIST, released the AI Risk Management Framework, which is a voluntary guidance document for managing and mitigating risks of designing, developing, and deploying AI products. They've also released other materials with that framework that gives some really good guidance on AI regulation and governance. So let me talk very briefly about AI. I'm sorry, about alternative vehicles. So at the end of the day, in terms of liability, really it's sort of what is the search and what is sort of who is the human behind this? And under the US, typically products are and liability is addressed either by bilateral contracts between the end user and the provider of the technology. Also, tort laws in the US, particularly if there's negligence by the tech provider. And then, of course, statutory. Like AI, there is no federal framework for autonomous vehicles. AI testing and development is governed really at the state level at this point. There's some early adopter states that have created legal frameworks that encourage testing and development, and many others have not. The U.S. Department of Transportation, under previous administrations, issued plans and strategies for AI development. This included 3 advanced notices of proposed rulemaking. And only one of those actually made it to final. This was the last one was moved to final rule and published in March of 2022. This is the first Department of Transportation final rule, and it effectively amends occupant protection rules to account for autonomous vehicles. There have been other steps towards the advancement of federal AV framework. There's a standing order requiring reporting of incidents in the US involving vehicles equipped with autonomous driving systems. Some of this data has been released already and certainly being closely monitored. Again, not a comprehensive framework for regulating, but it all moves in the right direction, at least in terms of guidance and data collection. I want to turn very briefly to blockchain and Web3. Of course, not exactly AI, but certainly analogies worth mentioning. So what can we learn, and can we learn anything about how the US and other countries are handling technology? Well, maybe existing laws applied to new tech and new asset classes. It's been a challenge, to say the least, in the US with respect to Web3 and crypto. There are certainly bad actors in the space, but the tech is not inherently bad. In fact, it's inherently good for so many industries and to have a positive social impact. That the guidance we have in the US is not through policy or lawmaking, rather, it's been through the enforcement actions under existing laws. And so very much like AI and AV, some have argued that existing laws are good enough. Others believe that new legal frameworks are needed. Again, blockchain and Web3 is a different technology, but the same theme. So the consequences really around uncertainty for both regulators and innovators is really that we stifle innovation. And so I get back to my original quote, and that is, we have an unprecedented time for technology and innovation. Thoughtful policy and regulation is really critical now more than ever. And so I turn really to the panel now and some questions on what is the right balance? How do we strike this right balance where we are protecting consumers in a way, certainly that we can continue to advance, but also without stifling innovation? And how can tech leaders, academia, research, et cetera, make a difference in driving this forward? Thank you all. Look forward to further discussions.
Thank you, Joe. Great overview, splendid talk, many thanks. We already have 2 questions from the online audience, at least, and we have 1 question here from the Berlin audience. Yeah.
So I have thank you for a nice presentation. So what I think is when you were talking about this, this is a comment. This is a comment on the, I think that if you look at the AI Act, so it has this idea that if there is this kind of a system required this third-party conformity assessment when it comes to the market, like cars are. So it means that the safety systems of the car are actually high risk in terms of AI. So because cars have the safety parts, if you have self-driving car, it actually contains the safety components on that as well. And toys are there as well because you can actually swallow some things, for example, or you can have bad content for the kids. Yeah. So these are the parts of that. But I have actually actual kind of questions for you. It's about the generative AI. And when it's discussing about that, and especially if I think about the lawful kind of a definition of it, and then you look at the technical part of it, it actually says that every output that the program does is actually generated. So you cannot really specify in a local sense what is a generative AI content if you say that generative AI is the output would be under kind of scrutiny if the system. So you cannot define them out of it. And there are some, of course, the general purpose AI has a kind of similar type of, let's say, definitions that actually break the technology neutrality of the system of the AI. That's actually, that is a really good part of the AI, kind of AI Act regulation that does. But now there is a heavy discussion in the EU how it actually will go, and this is part of the discussion. I think that perhaps they find a sensible solution for that. Any comments on that part?
Yeah, thanks. Those are actually two great questions. The first one reiterates or mirrors what also one person online wrote, and that is saying, well, you know, cars are high risk. And I agree, there is, of course, all kinds of product safety regulation in place. But what is not the case is that it is high risk under the AI Act. If you look at Section 2.2, it specifically says that all the legislation from Annex 2, Section B is exempted, and that is all the transport regulation. So that means that, of course, what we have in terms of cars right now, all this applies to cars that are autonomous as well. But it does not have any, and I've talked to a lot of people who work in the industry, it does not have any rules for how to assess AI built into a car. In fact, what's being done is that this is not actually checked at the moment because there's just no rules guiding this whatsoever. There's no data governance structure. There's nothing comparable to the Articles 9 to 15 in the AI Act that would be in the, you know, in the general car product safety regulation. That's the problem, I think. And that continues under the AI Act. For as much as I know, and all the experts I've talked to sort of agreed to this, but after first saying, hey, how can this be? But, you know, if you look at it, at least that's my impression. But maybe you have a different view on that. The second question is excellent. Yeah, so if I'll try to rephrase it to make sure I understand it correctly. So are you saying basically generative AI is impossible to define? And is that what you were saying? And therefore you cannot exempt it because you would have to know what you exempt, right? Is that what you're saying? Yeah, that's both correct and incorrect. I think it's correct in the sense that, of course, it's super tough to define generative AI, just like it is super tough to define AI in the first place, or general purpose AI systems. So I totally agree that from a neuroscience perspective, it might be very difficult to define this. And maybe some of the tech persons here would have a view on this. I'm just going to comment on the legal part. The fact that something is impossible to define has never stopped lawyers from defining it, you know, in the first place. And that's a good and a bad thing at the same time. But, you know, at a certain point, we have to make some rules. And if we want to make these rules apply, somehow we have to go for some kind of workable definition that will have type 1 and type 2 errors. We just have to try and minimize the cost of these errors. But I guess that the CJU has been very plain. So said, you know, if it's information, something like a newspaper article, the PLD does not apply. CJU doesn't really care about how to define it, but I'm 99% sure that the CJU would say the same about any kind of generative AI output, however you define it. It's basically a bit like this porn thing, you know, you know it when you see it. And if the CJU thinks it sees something that looks like a newspaper article or a snippet of it, then it will not apply the PLD framework. It's just, and I'm not saying this is good or bad. I think in the end it's good that they do not apply this, but rather more specific speech regulation. But that's just a matter of how I understand the law. And again, reasonable people may disagree, of course. But maybe someone from the tech side wants to say something about how to define or how to approach generative AI.
It's a very hard question to answer here. I think generally it comes back to the use case definition for any AI, whether it's generative AI or not other AI. It's so hard to say when it starts or when it ends, and it so strongly depends on what use case you need to apply it in. So I think also for generative AI, we need to be very use case specific and then say, look, like certain use case we can do, certain we can't. But like regulating it overall, I think it will just be impossible. Like I don't want to be on that side making that definition, basically.
Yeah, I mean, of course, there are these textbook definitions, right? That generative AI tries to learn the underlying data model, like that we want to approximate P of X, for instance, and discriminative model rather try to learn predict labels given a particular data point, so P of Y given X. But in practice, as you said, I think this very mathematical abstract definition may not help you to really approach this in practice, because depending on what use case it is and how you like turn these terms, it can be very different. So I agree, this is a tricky thing.
And as you all know, iudex non calculat, so the judge does not calculate. If you come with certain variables and so on, that might not be very helpful, at least in the EU context, that is not so much, has not so much been trained in law and economics. We have a further question from the audience, and I'd like to pick up one more question from online, and then we'll proceed with the next two input statements.
For the AI liability, I'm thinking, is it a sharing liability for all of us? Because actually you have a provider side, as you said, the first case, it could be the wrong side of the AI models or whatever with the cars to hit the people. So it's maybe more on their side, but maybe for the second phase, you can say it's more for the people. When we interact with the AI models, there's something wrong also for us, you know, and then it could be a sharing liability. What I say here is only two stakeholders here, but when you think of the whole ecosystem around the Earth, there are so many things to consider maybe, because we are helping all together to make the models getting better, I'd say.
Yeah, Joe, do you maybe want to chime in and say something about the previous questions, and also maybe something about contributor negligence if you want to?
Yeah, thank you. I think that, to your point earlier, lawyers can come up with a definition of AI. I think that's not the challenge. I think the challenge really is how do we apply that in the context of different use cases and particularly different industries, right? Should we be regulating AI under a generic law that applies to, let's say, financial services and healthcare, or should we be looking at it with specific use cases in mind? And I think the issue really is, the threshold question is, are we regulating the technology or are we regulating the activity? And I think the concern that we have is really around the activity itself and not the tech. And we've got to be very careful that we don't regulate technology.
Yeah, I totally agree. And that's precisely the point that is problematic at the EU Parliament right now, because of course the general purpose AI regulation started off as a technology regulation, as regulating the GPAIS, or the generative AI model per se. And slowly but steadily, it has been pushed toward further activity regulation. I've been very vocal about, about regulating use cases only and not the technology itself. And we'll see just where it ends up. The fact that there hasn't been a vote yet on the AI Act is precisely due to this debate at the European level. So yeah, thanks. All excellent questions. I'll take your question later on in the general Q&A. Okay. Just one question here from the audience, from the online audience. One person asked, so what's the difference in between a defect and a feature? So basically the idea, is it a feature or a bug, right? And again, that's a very good question. I'm going to take it perhaps for EU law, and Joe, if you want to chime in concerning US law. For EU law, there's a clear definition of a defect. and that is being amended as well right now in the Article 6 of the Product Liability Directive update. Short story is something to the effect if it leads to the product not having the kind of safety that you could expect as a reasonable consumer from it to have. But that's, of course, a formula that, nobody knows what it means. So in the end, particularly, what does it mean for AI? Many people disagree. I've written a bit about it. Other professors and law scholars have written about it. I think, first of all, we are going to need standards. There is a lot of discourse, even a lot of work around standards for AI right now. So basically, if you fulfill these standards, it's not a defect. If you breach those standards, that's going to be considered a defect. But for as long as we don't have them, and it's going to be a long time in the making still, we still have to find ways to define what it is, a defect. And here, something comes in that is being used in the EU and that comes from the US, and that's called a risk utility test. So that's a general definition of a defect under US product liability law. You basically have to ask, is there a reasonable alternative design that would have prevented the accident? So let's say that, for example, we have an autonomous vehicle that crashes into a person because it's moonlit night and it's also raining, and it turns out that the car never was tested during these conditions, right? And you could say, well, a reasonable alternative design of the car would have tested it under these conditions. But that would have prevented the accident, because if it had been tested in this way and trained in this way, it would have recognized the person. But how much more does it cost? That's the second question. And the second question is, does the additional cost, so that's the additional disutility of training and applying the model, does that justify the risk reduction that you get? So basically, if you have to pay 1 million euros to prevent a harm that would be, $1 per person, and it's going to rise in 50 persons only per 10 years, then no, you don't have to do it. If it's a feature that costs you 200 euros, but would prevent a harm of 2 million euros, then yes, you have to do it. And there are, of course, borderline cases in between, but that's a general idea. And of course, again, it's going to be tough to implement this in practice, but at least that gives you some kind of a framework. And here you see UDEX does calculate, in some cases, this is a learned hand formula, which comes from US law, actually from a judge who wrote it up as a formula, but that's US style law and economics, basically. Joe, do you want to add anything?
Yeah, I mean, I think there's of course in the products liability question in the U.S. is, what's the proximate cause, right? And did the company know that there was going to be a problem, and did they make a decision for that trade-off, right? Fix it and or not test it for again as a sort of a cost benefit, and that's been a products liability question and issue for many decades, certainly in the auto industry. From a software perspective, the software itself would likely be governed by the Uniform Commercial Code, and all of the most bilateral agreements do disclaim liability under any kind of warranties, any kind of statutory warranties, and whether or not that's going to apply here in the software case, when it certainly in the automobile where we've got product liability cases. How does a disclaimer in a commercial agreement apply in the US, right? And that's going to be sort of that's always an open question whenever there's a defect in software. But if you look at something like financial software historically and healthcare related software, most of the software companies that I represent are not going to take massive liability, given the fees that they're collecting for the software, for a defect in software that, let's say results in $1 billion trading loss, or, some, major clinical trial problem in software. And so we've got to find that right balance where, there isn't sort of an unknown bug in software that creates massive liability for software providers.
Thanks. Yeah, thanks. Lots of questions still open. And of course, as you can see, this can be expensive for startups and big companies alike. And that's why it's so important to also bring in the industry perspective and the research perspective, which is what we're going to do in the next few input statements. So I'm going to hand it over to Rasmus right now, who's going to say just a few words about himself, and then proceed with some statements on how this whole AI liability and AI regulation framework in the EU, but potentially also beyond, is viewed from the perspective of startup entrepreneurs. Rasmus, many thanks for joining.
Thanks, Philip. Yeah, I'm super excited to be here today. I will give the industry perspective. My background is actually in machine learning research, so I've been working very technical for a couple of years. Trained many neural networks during my life, so as such, I think can give that perspective. But now also the perspective of putting also high risk applications into practice. We've incubated around 10 companies, some of which use AI in high risk areas such as healthcare. And maybe talk a bit about the perspective from a company perspective. So how do we think about it? Yeah, less the legal perspective. I think first of all, I think like right now we're talking a lot about liability and risks, and that always gives it a very like negative connotations. I would like to spin it around and say actually, use cases which have liability concerns are also actually areas where we can take a lot of responsibility, and those are maybe exactly the areas we should tackle. So, and I think that's also some problem with the EU AI Act. It talks always about risks and the downsides, but honestly, those are exactly the applications where we also potentially can have a lot of upside. So if you think about, I don't know, autonomous driving, right? Like there's like 1.5 million people dying and car-related accidents. So that's our benchmark. Our benchmark is 1.5 million people dying because we are making mistakes when driving around the car. So I think it's very interesting to think about encouraging people to first of all address those problems and build companies there. And yeah, I think the current terms don't necessarily are so encouraging there. And also, secondly, make sure that we compare it actually to the current human benchmark and then think about what can we do better. From a pure commercial point of view, exactly those areas are actually also areas where you get paid more. I mean, if you just think about it from a company perspective, then you take more liability, then you take more responsibility. So I don't know, say autonomous driving, right? Like you have levels of autonomous driving. If you just have a display in the car highlighting some bounding boxes where things are you might want to watch, probably people will not pay much for it. You as a company will not build great business. Now, if you actually build a fully autonomous car, the value is actually much larger, right, for the consumer. And so as such, I think you should be encouraged to basically build more autonomy in overall and then get also paid for that. I think from a regulatory perspective, and that's also, I think, one of the common misconceptions is generally not about like more or less regulation as a company, but it's about clarity. I think the worst thing is uncertainty. So we've also seen that with our companies, that when you talk to customers, and you have 3 extra loops because the customer doesn't really understand if this is what you're doing now actually okay. And even though all the documents suggest that, if there's like, as you said, Philip, like 2-3 different laws that basically cover your case, and there's a lot of uncertainty and everything, and it's very unclear what now applies to you, like that will just create a few more loops when interacting with the customers. And maybe then the customer just says, look, like, yeah, even though the risk is like 0.001%, yeah, we're not going to take the risk because you have somebody on their side responsible for legal, and all they can do is lose basically. So they will just say, okay, let's rather not do it. And who ultimately wins there is the lawyers, right? Because they can write like long statements on both sides, like why this is now possible or why this is now not possible, and they get paid per hour. So the more they can charge, the better it is for them. So there's like in the whole system, I think like some misaligned incentives which kind of make things a bit more complicated. And this uncertainty only ultimately gets priced in, right? So investors will look at it and be like, oh yeah, I don't know if there's some risk to actually deploy this, and maybe the company gets shorn down. So I invest on a lower valuation, or I don't invest at all. So I think, yeah, all this uncertainty just needs to be reduced as much as possible, and that should be the kind of KPI for the lawmakers, and not more or less regulation. And that does anything that kind of creates clarity, double regulation, also clear guidelines, I think is good from an industry perspective. The other thing that is kind of like right now addressing, Philip, you mentioned that also before, is that basically, on the EU level, there's a lot of discussion right now on regulating AI overall. And even though I'm also kind of a bit blown away what's been happening in the last couple of months, and also see some of these long-term risks Elon Musk and the others are seeing, and those should actually be thought about. Right now on the EU level, I mean, we're very much trying to regulate the technology overall, which is just I mean, I don't want to be in their shoes just because it's so dependent on the use case, right? Like the same AI that can be used for like cancer detection can be used for modern warfare, and it's exactly might be exactly the same algorithm. So there's just no way in regulating that. That should be purely use case specific, and we have a lot of regulation. Like I mean, even before the EU AI, right? Like we're active in healthcare. There's existing regulations. Let's just extend it. And again, it's I think some misaligned incentives. Like if I was, and the same for cars, right? And so I don't know. Like I think like just on EU level, you know, it obviously sounds sexier if you write the EU AI Act and can build a career on that. Basically put all the law under like one umbrella, then going to like 27 existing regulations and rather tweaking them by like 10%. Like that's not so sexy. That's like very nitty-gritty work. And so now we have this big EU AI Act, but people realize, oh, it's actually really hard. So it sounded very nice in the first place, but now, yeah, it's just a very unthankful task. Yes, those were some points about that. I think generally what I find interesting, like there's a lot of discussions now around liability, about bias, and these kind of things. And I think those are all not new problems, right? Like if you go, I don't know, into a bank and try to get a loan, they will also look at you and will be, okay, you know, Philipp has a shirt, you know, I also have a shirt, you also have a shirt. Like depending on how we address, what ethnicity we have, people will already rate you before you even opened your mouth. And so we have these biases in all kinds of industries. It's not a new problem. The beauty we have now with AIs or data-driven approaches is that we can make it transparent and then also actually figure out, okay, what features do we want to use? How do we want to regulate it? So I think a lot of the problems are not new. Also, humans are like crazy black boxes, right? Like if people make mistakes, like if a taxi driver, I don't know, drives into like the wall or kills somebody, like you also don't know, like was this now led this person to do so? Was it like on purpose, or was it because there was some, I don't know, light interfering with the person or some random thought coming up in their head? Like that's all a black box, and it's very hard to find it out with AI. Yes, it's also a bit of a black box, but at least a bit more data driven. So I think hopefully we can address some of these issues better. So I think overall it's more positive than negative. On the use case side, I think yeah, like and one more thing on the regulation side, I think generally another misalignment of incentives is basically that a lot of the big tech companies obviously have like 100, 150, 500 lawyers or external lawyers they can pay. So for a lot of the cloud providers, I mean, it's not a problem if there's a bit more regulation. It just makes the small companies grow less quick. And who has more lobbyists? It's usually also the large companies. So again, some misaligned incentives there. From a use perspective, I think like even if you regulate it by use case, it's also not so easy, right? Because use cases change all the time. There's always new use cases you can open up. And also the way you employ the use case makes a big difference. So depending on, I don't know, in healthcare, if it's just decision support, if it decides autonomously, if it can bias a doctor, what kind of warnings you show, like there's a very different risk associated with all these different kind of sub-use cases. And so it's going to be very hard to make like long lists and say these use cases okay, these are not okay. And I think one direction I find quite interesting is to say, look, like innovation is just moving so fast. Let's just move that to the private sector and basically ultimately insurance companies around that price the risk and then also insure it, and as such be much more flexible than lawmakers and kind of basically dealing with these new use cases coming up and pricing that risk. Yeah, but overall, I think these discussions here are super fruitful. Like, I mean, we were actually neighbors until Saturday, so we've discussed once in a while by coincidence, and you know, we just realized, like, you know, as a lawyer versus as somebody building companies, you speak a different language, but you're dealing with the same topic, and we need exactly those exchanges and dialogues to kind of converge to something that makes sense for humanity. So yeah, I'm very much looking forward to the discussion later, and with that, handing over.
Yeah, thank you. Those who know me know that I approach these kind of topics from the explainability perspective. So I mainly do research on explainable AI, explanation methods, and I will share with you my view on liability and this lack of robustness topic. So basically, we live in very interesting times. We have like AI models which behave like a genius, which can beat human experts, professional Go players, which can do crazy things in a very accurate way. On the other hand, we also have AI models which behave very stupidly, which make very stupid mistake every child wouldn't do. Like treating a traffic sign a truck as a traffic sign, or classifying medical images based on some marks at the boundaries. So we have these very diverse strategies learned by these models, and one reason why we have this discrepancy is the black box nature of our models. So when we train AI models, a lot of stuff comes in, data comes in, something is going on, and later the result comes out. But basically, until very recently, it was not really clear, like how these models decide why they fail, and how they kind of do this step-by-step processing. And basically, so the bigger question is to trust or not to trust. So should we trust a model which we do not understand? And then when thinking about this question, I thought there are areas in life, for example, when you want to construct an airplane in these, or a house, a big building, in these areas, things are very modular. So if you want to like really construct an airplane, you have to certify the quality of every screw which is used in the airplane. So it has to fulfill certain criteria, it has to fulfill certain norm, it has to be robust to certain pressures and so on. So you kind of build things from very small parts for which you can very accurately assess kind of the quality. And of course, you also do checkups for the whole system, but you basically can trust that each individual part fulfills certain criteria, so you know the boundaries when they fail, so you can assess very well like what's going on and which are the boundaries where your systems work. On the other hand, you have disciplines such as drug development, where people develop things, new drugs, and we also have developed very good procedures to test these drugs on very different levels, having animal models and so on. But in the end, often researchers, drug companies do not fully understand the mechanism behind the drug. So the drug kind of works, and you can be sure that it has very little side effects, but we don't fully understand the biology behind it. And basically, with AI, with machine learning, what has been around for a long time is to try to also develop this kind of tests. So even if we don't understand the model, maybe we don't care, but we evaluate it on some data which it hasn't seen before, some test data which we collected for this testing purposes. And this approach has been performed for many years and has been part of these international challenges. But as you will see, although this is kind of a valid approach that you try to evaluate the quality of your model on some unseen data, it can result in very bad assessments. So therefore, my claim is that you need some kind of understanding that just testing the performance of the model is not enough to really assure trustworthiness. Basically, we have a lot of explanation methods. I will not go into detail here. So this is something which I deal on my daily basis, to develop methods to assess techniques, to develop also theory for these techniques. They show us kind of on which basis a model has done its decisions, which features were most important, these kind of heat maps we can compute with various approaches. In this case, the pool table was classified because of the pool table, also because of the balls and the queues. And with these explanation methods, we kind of found a lot of different problems with AI models. So maybe the most well known is this horse example, which we found in an AI which won an international challenge. So people compared the methods on independent test data, assessed the performance, but didn't realize that a lot of these images with horses were tagged with a watermark, with a copyright tag. And so the model kind of learned to detect this copyright tag instead of looking at the horse. And people didn't realize for almost a decade. And this shows you that a lot of things can go wrong. And also other groups have reported these kind of strategies. We call this clever Hans type strategies, that things are not as they seem to be. And explainability can help you to uncover these problems. And very recently, we kind of wrote a paper, which is now in minor revision, where we try to go the next step, try to go beyond this very simple type of explanations, beyond this attribution maps, towards a more explainable AI 2.0 approach, where we not only tell the user where something is relevant. So in the horse examples, you saw that the heat map showed us where something is relevant in the image, but we also want to understand what it is, what kind of feature is used by the model and how it is integrated into the decision learning process or the decision-making process. I will not go into details here, but basically what we do is we try to interpret this neural network on the intermediate layer in a more human understandable concepts and give a more full disentangled explanation showing like what type of concepts the network is using to arrive at its decision. We can use reference data for that to really not only understand in the input space which part of the image is important, but also which neurons in the neural network, which parts of the neural networks are playing which role, and how these concepts are combined in a final decision. So I think these kind of techniques help us to uncover the whole decision-making process. And we think this is a step forward to understand how representations are built up, how concepts are built up, and then to get deeper understanding on the whole mechanism of decision-making. And basically, I think what's another direction in research which is very interesting is to integrate prior knowledge into the learning via explanation. So basically, if you know in certain areas in physics and chemistry, we know certain things which should be fulfilled. There are physical laws which you want your model to fulfill, to respect. And one way to integrate this prior knowledge is to directly use it, integrate it into the laws. This is something which is very interesting, which many different groups internationally try to use to get more trustworthy models, to have models where you can really trust that it respects certain physical laws or certain biological processes. But of course, as you may imagine, explainability is not enough. It's not enough to audit your AI models. So what we are now looking together with colleagues from TÜV and BSI is to really try to get a grip on the whole life cycle of AI. So explainability just tells you what the model has learned, tries to explain the decision process of the model. But I think what we need to do much stronger also in research is to also develop quality metrics for the data, to have certification processes, benchmarking processes for the data side, and try to cover the whole development process of AI. Because once the model is trained, even if we can explain it, it may be too late. So the model already has learned certain strategies, but we should get a control over the model's behavior from the beginning when we acquire the data, when we label the data, when we train the model, and later on in deployment, we have to develop processes and strategies to control it. So similar to what people do in drug development, they have certain procedures which, in the end, are fulfill the quality requirements, or leads to the fulfillment of certain quality requirements. And I think we need these kind of procedures also in AI. And yeah, with that, I'm very happy to start the discussion.
Wonderful, thank you. I just have a very brief comment here because the question of explainability is also intricately and inherently linked, I think, to the question of liability, because we talked about alternative designs, right? And you just now said that certain types of mistakes are easier to find if you use an explainable model, which actually led us, and that's an insight that, you know, intuitively has been around, I guess, for some time. And so in 2020, we published a paper that's called Explainable AI under Contract and Tort Law, in which we show that under, and this holds, I guess, for US and EU tort law, but correct me if I'm wrong, Joe, if there is a reasonable alternative design in the sense that you could have made an intransparent model explainable by designing it differently or by using an exposed explanation model, and that would have likely prevented the accident because you would have seen that actually it's a clever hands thing and not a genius model. Then, of course, that may make you liable if an accident occurs because you should have used the explainable model. So long story short, failure to use XAI or failure to use state-of-the-art explainability techniques may, in the end, result in liability. There's, of course, many more nuances to this, but that's perhaps an interesting general concern. Maybe before we open the floor for questions, maybe I just want to give the other experts here on the panel the opinion to react. Maybe briefly, but Joe and then Rasmus and Wojciech, maybe you want to go ahead and share your thoughts on the other presentations.
Yeah, sure. Thank you. I think from my perspective, again, looking at this from the protocol side and the technology provider side, the themes of fairness, explainability, and transparency all make a lot of sense. And if you look at it from the context of, you know, data privacy, you can explain, for example, what you're doing with the data. But I think as these models get more complex, I question whether, as a practical matter, explainability is going to be useful for anybody other than, you know, a computer scientist or a highly technical person to understand it. And so my question really is a practical one. You know, how do we, to the general, you know, consumers, how do we actually explain this technology? And where are the limits of explaining that when it's so complex and so layered? I just don't know how we can write law and give guidance around doing that, but how does that happen as a practical matter? And that's my concern from a software provider side.
Yeah, excellent question. I think, I mean, explainability can be useful also for the layman. I think if you go to a medical doctor and have some disease, so you want some kind of explanation for treatment, even you may not understand it, or even it may not be required, right? So you want to be involved into the decision-making process as a patient, and for that, explainability is kind of essential. This is, I think, yeah, point number one. But on the other hand, I think explainability can be a good tool for regulators, for people who are checking the AI or developing kind of these procedures to make sure that the AI fulfills certain criteria. The explainability can be one important aspect, but of course, maybe not the only one.
Yeah, again, I guess like adding to that, I think we just have double standards. Like there's a lot of explainability we can't even do when we talk about humans. So now actually with these AI models, there are some tools and offer some explainability. Yes, they can't explain everything. And yes, it's harder the bigger complex the model is, but that's why we're using such a complex model, because the problem we are trying to solve is complex. So I don't think we can expect that it's going to explain everything, especially if it has superhuman performance, and it might be even harder. But I think it's so great to develop those tools because they're both helpful in the development process. I mean, they might also show like artifacts there in your data set, and so you can basically, you know, rethink your data collection. They can also be helpful for some of the users when they get a feel for in computer vision, what image regions were relevant, and ultimately also for regulators or people certifying it. So I think it's super important to develop these tools, but yeah, they will not answer all the questions, but I don't think you're claiming this either. So we're all good.
And maybe just a quick note on that to add on it. From a legal perspective, of course, it's going to be very complicated in many scenarios to actually come up with a good explanation, particularly at decent cost. But again, an obligation from the legal side that would be necessary, to have this extra explanation to save you from liability is only required if there is a reasonable alternative design. So if it's reasonable to use it, say, you just buy a good add-on, an explainability add-on, if that was available, for 1,000 euros, again, for your series, and that helps you, minimize costs or expected harm that is greater than that, then you're supposed to do it, and if not. And of course, that's going to be tricky in any specific use case. And as Joe said, the important thing is that those who are actually confronted with it, who receive it, that they understand it. And just one final remark on this, my sister is a medical doctor, and she received her final training. She graduated from the program, a couple of years ago. I think for all medical doctors that are starting right now, they need to have classes, an extra class on machine learning, not on how to build machine learning, but how to reason with, be helped with, and critically analyze the output of machine learning. Because they're going to be using, this cancer stuff all the time. They might actually, and I hope they will, use generative AI to write patient letters of this stuff, to free up their time to actually treat patients, not do bureaucracy work, because people are dying. Again, people are dying because our doctors are working nonstop to fulfill all these documentation requirements. I know this for a fact, and this is, again, a point where we see the huge potential that generative AI and other AI systems can have. And I fully agree that, we need a balanced approach and not only look at the risks, which in Europe we have a tendency of doing, I guess, at least in the regulatory field. But what's important also is to educate professional users. Professional users must be in a position to spot when using an add-on tool that this is actually clever hands prediction, to throw it out, or to assess that, that makes sense, and let's use it for this and that subcategory of cases. Okay, Joe, any further thoughts at this point?
Yeah, just an added point to that. I think it's a great point about educating, particularly in healthcare, physicians, but really in other industries, financial services. You can think of a lot of other examples, but it does sort of raise the issue as if you're a software provider or a product provider to a particular industry, healthcare, great example, where do we draw the line in terms of liability if a physician, for example, relies too heavily on an algorithm when they're supposed to just be using it as a tool to help them with their decision, but really they rely on it to actually make the decision, and sort of where's the line in terms of who's liable for a bad act?
That's, again, a great question. I could spend 10 minutes trying to tease apart the EU case law about it, but I will refrain from doing so and rather open the floor to questions. Do we have any questions from the audience? Yeah, there's a couple. Maybe the lady from the back. Maybe can you briefly identify yourself also?
Sure. Good evening. My name is Salwa, and I'm building a product in the space of generative AI. So my question is related to generative AI. First of all, maybe you have heard about Italy banning ChatGPT. There is an open letter being signed by prominent AI leaders asking for a moratorium of 6 months on any development of general AI. And I think the concern is coming from the angle of societal change, in this sense that it's hard to make the argument against liability or explainable AI. It's rather a matter of unemployment and how the rapid change is gonna affect society. So, right now in the EU, let's just take the example of Italy. They banned it, and they didn't provide any reasonable explanations for why, or any path to a more regulated ChatGPT. So where do you see the development in terms of legal arguments against banning entire products based on just societal change or fear of unemployment?
I think it's a very stupid idea. Like it's like, you know, when the first computer came, it was also not let's ban the computer for 6 months, close our eyes, and then hope everything is solved. So I don't think that's going to solve the problem. I think it's more about having the people on the EU level. And I mean, I know they're looking in their direction. I know who anyways think about AI regulation, maybe kind of update their thinking, maybe actually throw everything they've wrote so far and start on a clean slate. Because I think a lot of, I guess, like current work has also been based on like where I was like, you know, 1-2 years ago. And yes, things have moved very quickly. And yes, I think they should think about these issues, especially, you know, the technology will anyways be there. So I think like stopping it is very hard and has rarely worked for technologies very well. The challenge is that basically these tools are getting more powerful, and like ultimately, you know, if you just have a computer and it's one of these smart models, and at some point they might actually maybe improve themselves, you could do a lot of harm as an individual using these models. And we need to think about like, how can we work with that as a society? Like what are, I don't know, liability that will happen or like fines that happen, but like a lot of this stuff will be very open source, very accessible, and that will be not stoppable anymore. And so, yes, the concern is real, but I think what Italy is doing now, just banning it, is like, I think not solving any problem.
Thanks. I have a slightly different point on the Italy example, of course, but let's take it step by step. So, but Joe, maybe do you want to jump in first, and I can share some thoughts on the EU landscape?
Yeah, I think at a fundamental level, there's a lot of issues with that, certainly banning software, but from a US perspective, it could actually be a constitutional issue in that software is viewed as protected speech. And so it's a fairly complicated question. We're seeing it not just in AI, but also in Web3 about actual banning the publication of software. And we could see things like that going all the way to the Supreme Court as a constitutional question.
That's, of course, a very interesting perspective. Commercial speech is much more protected in the US than it is in Europe. And therefore, you have a whole different landscape of case law and concerns that apply in addition in the US. With respect to the question asked here, I mean, the moratorium, I've already posted online a few days ago my thoughts on this, saying very early on, you know, I'm not joining this. And why? Because clearly, as Rasmus just said, it doesn't make sense, particularly if you don't have Russia and China to join. I mean, it only means that other people are going to be catching up. And particularly when you look at Musk, that ultimately probably orchestrated all of this, at least signed it as a third person, you can't help but ask yourself if, you know, he just wants other people to pause so that he can train his what he announced as his free speech model without any content moderation, then to catch up with OpenAI, with which he is now not on good terms anymore. So I view this as a very partisan strategy. Very clear that the vast majority of AI researchers have not joined this. I think they have barely garnered any more signatures since the first day. So this is really a literal non-starter. But the concerns are real, and we should take them seriously. But we should address them where they belong. And where is that? The concerns are, of course, with unemployment and so on. Well, that's a different matter, and we need to make sure, you know, that we have programs, educational programs, and so on, in place that enable people to actually work with these tools rather than being replaced by them. And as for now, most people, even in the AI context, you know, machine learners, they say the best strategy is actually human-machine teaming. It's not replacement. Very few people are talking about replacement. It's really about, you know, teaming up. But the really important thing, I guess, is that from a regulatory perspective, this main concern about, you know, videos of sexual violence, you know, hate speech, fake news, mass-produced, automated fake news campaigns to sway the next US or other global elections, that's a real concern. But in the EU, we do not address this in the AI Act. We have regulation in place for that. That's the Digital Services Act. And in fact, what we need to do is update the Digital Services Act. And that's something I elaborate on in this regulating ChatGPT paper. So I think what people are doing right now, of course, because the AI Act is currently being negotiated, they try to put everything in there, but actually where it belongs is a totally different area. And we need to be much more precise here. But also we need to be sort of clear on the fact that I think EU Parliament will not pass any AI Act without regulating ChatGPT. There's just no question that they will do it because there's so much concern about it. A lot of it is irrational. A lot of it is also perhaps based not on the right facts or understanding of the technology, but we will not see, I think, an AI Act coming out of EU Parliament that does not explicitly have this label of, we're taking care of it, we're regulating ChatGPT. So the question is, how do we do it in an intelligent way? And I think use case based, and then maybe with some, minor divergence of the DSA, that could be a way forward. Last point, the GDPR, and here's where I actually slightly disagree with Rasmus. Because I think in that particular case, there is perhaps a reason for it. They said, if I understand, I haven't read the whole decision yet, but what seems to be driving it is intransparency. Again, intransparent data use. And it's true, and I think it's a concern that many of us have. What is actually OpenAI doing? They've called OpenAI, but it's a kind of a total misnomer, right? I mean, they're not telling us what kind of data they're collecting, or whether they're using our input to train the model again, or how they train it, where they're scraping the data. It would be great to know it, and it wouldn't put them at a great disadvantage if they told us, we took data from there and there, we have these quality mechanisms in place, and so on and so forth. So some kind of regulatory and particularly civil society scrutiny would be enabled by them just being more truthful to their name, to be more open. And that's precisely what the GDPR thing is about. It's not about banning it per se. It's just saying, we have transparency obligations in the GDPR. Please fulfill them. Please tell us what you intend to do with the data. And I think there's nothing wrong with that. Actually, they could just come forward and say what they're doing, and that would be all fine, at least from that perspective. Wojciech, do you want to add to that?
I have another follow-up question regarding open source software.
Okay, maybe real quick, because we have another one, and then we are kind of running short of time. But just on open source, that's true. That's also a really difficult point. I have something on this, on the regulating ChatGPT and on the AI liability paper as well. And just to say that at the moment, this is in a bad spot, because particularly with generative AI models, the EU Act says explicitly it even includes open source models. And you can imagine if you have these massive liability concerns and you have all these compliance features, no open source developers in his or her right mind would continue doing that. Okay, sorry.
Okay, thanks again for the discussion. That's been really interesting. About explainability, there's one catch that not very many people are actually noticing, in the sense is that rules can have very complex consequences. So if you have a couple of 3 or 4 rules, you can actually make a system that actually leads to very complex, unpredictable outcomes. So explainability is not to say that you don't have unintended consequences for the system. It is not guaranteed for that. So in a way, we can say that if you have a bigger model, in a way, you could say that, okay, you can start looking at the features it would prefer, kind of use it on. Very often you can actually find out of data input that makes it kind of problematic. Even the Go example that you are showing is such a thing that there is some very bad playing that actually leads it to lose. So you can do this adversarial reinforcement learning train. So that is also the one comment on why I had to, then you can answer the question about that. So it was about the GDP, kind of a chat GDP question that you had. Essentially, the problem is on GDPR sense, it is saying that they're saying user input, what the people are putting in is actually how it is going to be used. And they say that if it's used in training, then there is no disclosure of that this would be happening. And then you can actually have the situation when you are kind of providing the same input as an output somewhere else with this retrained, and then you actually break in GDPR if it's personal data that is coming from the users. But actually the ChatGPT last was trained in 2021. So it's not been trained by the new user input. but that we actually know. So this is what they say, that it has not retrained, because one retraining of the system costs 10 million. So there is but they actually have continuous, they can do the training that they haven't say that. So it's easy to say that, for example, that it is perfectly okay to do something like we are recording the session in order to improve the system. And this is actually, you say that, okay, you continue using it, and then you have given a consent for it. So there is a system for all cases that goes out of it. So they are not actually understanding really what the technology is. But this is, and I agree with you that it was a GDPR. Yes.
Yeah, I think relating to the first question, I think explainability is part of the solution. It's not the whole solution. So I think with explainability, it can help you to uncover some strategies to understand your model better, to uncover some misbehavior, which then you can use and try to address. I always think of it as more like an iterative process. So it's not like the explanation method gives you like one explanation and that's it, but it's like a more human-machine interaction, and explainability can provide valuable information in this interaction, which can help in the end to either improve the system or to improve the user using the system. But I think in the end, if we really what we want to have is something we need kind of, if we want to be sure that our system is making the right decision for 99.9% or so, so we need to also think about like how can we maybe restrict the data? Can we say, okay, if we put in normalized data which has certain boundary conditions, can we then prove or make sure that our system at least makes an error which is that high? So I think we also need to think about like more normalization, standardization, and in the standardized spaces we maybe will be able to make such claims that in most cases in this, if you put this type of input, then everything works. But of course there is no guarantee if you put something else as input on adversarial examples, then the system may break. We need, I think, also work towards this kind of certification procedures which can certify that your system works within certain boundaries. But I think this goes beyond just explaining how the system works. So there is more to do than just working as an explanation method. We have to come to this more certified level of robustness of AI.
Yeah, definitely I agree that explainability is a good thing. So that is not bad in the sense, but it is. But if you put a legal kind of terms on it, then it becomes harder because there is no limit when things become simple. You cannot. Yeah, so that is the problem on the setting. Yes.
There's one final question here, and then we'll just take a final round of comments from everybody on the panel.
Yeah, thank you. Philipp, I'm the CEO of a company which is a spin-off of the German Center of the German Research Center of Artificial Intelligence. My question goes to you, Wojciech. If you train a model and you have the cost of one, fully, I'm not speaking against any kind of, due diligence in doing your job, but, fully certifying a model, what would be the multiple? And do you cover that in your research as well? How much additional cost that would actually imply?
What cost it would be applied to fully certify the model?
Yes.
I mean, we are not there yet, I think, to fully certify the model. We are part of several initiatives, also like international initiatives with the WHO, the ITU, which try to come up with procedures to benchmark model, to think also about different metrics of different time points of the AI life cycle. And also these things we are looking at different use cases. So I think some of these metrics, these quality metrics are very much use case specific. So I think certain criteria you can try to certify on a general level, but a lot of these quality criteria or certification criteria will be in the end developed on the use case level, or we will need to relate to a certain use case. And I think depending on the use case, we are farther or less far, but we are not there yet that we can say that we could fully certify that the AI model will behave without errors.
Thank you. Oh, you had, can you have a very quick question? you had your hand up for a long time. I'm sorry.
Yeah, I have a question, and it's a very broad topic: securing innovation in AI. So for you, this is an open question, like for any of you. What's the key aspect that you have in focus when securing AI? Like, what's the most important aspect that you think it's like the tip of the iceberg? What's when you think about securing AI, what's the first thing that you like? For example, when I think about ChatGPT, I think about reliability of the data, of the answers. And for you in this topic, what's the key aspect that you think of?
Yeah, that's a great question. Maybe we use this for our final wrap up amongst the speakers. I guess we could all write a dissertation about that or two. Let's maybe in the final comments try to answer briefly this question of what's the biggest challenge we face, and also maybe come back to the original question of the panel. What would it take? What kind of regulation? What kind of liability would it take for these kind of laws to actually secure and not stifle innovation? So, Joe, do you perhaps want to go first? Esteemed guest from the East Coast, thanks so much again for getting up in the morning and joining us on this panel.
Sure. Yeah, I think it's a very hard question to answer because we have to look at which technology we're talking about. I think if we're talking about AI and self-driving automobiles, the answer and the stakes are obviously higher than you'd argue than ChatGPT, right? And providing information. I would argue that my default as a technology lawyer representing the projects, we are disclaiming, we warn users, if you're using this, the output may not be accurate. It may actually be wrong. It may actually be biased. And sort of more taking approach of disclosures and disclaimers, almost as, use it at your own risk. It's easier to do that, I think, with a publicly available generative AI product than I think it is to do with autonomous driving. And I think we can't really answer that question and say uniformly that this is how we're going to approach it for automobiles. This is how we're going to approach it for, healthcare related AI. I think we have to really look at it and say, there may be certain manufacturers and software providers that should be held to a higher standard, depending on what the product is being used for. And I think we have to look at it through that lens before we can answer this.
Yeah, for me, it's definitely, as you may not wonder, like explainability. So I'm deeply convinced that we need some kind of understanding. It doesn't need to be like a full understanding of the processes, of the model, of the data to secure AI functioning, and explainability is like one way to get this understanding. It can help us to build better models, to build more efficient models, to debug the data, to interact with the model. I think also this interactive explainability is something which I'm very much interested in. And in the end, I think we also have, as Berlin, as Germany, as Europe, also a big chance to really invest in these topics. I mean, we have very good researchers working on these kind of related questions, and I think we have to build on that. And I'm convinced that it's also like a chance to build a European way of AI, which is then explainable and certified, and in some case maybe fulfills certain criteria, quality metrics, which maybe other AI models are not fulfilling.
I think we just need to make sure, and that's what you said, that the applications are built here. And I think the biggest mistake we can do right now is kind of regulate things in the wrong way, so that then innovation happens somewhere else, because we've seen that now with the big platform and cloud companies. It's very hard to regulate them once they're like tens or hundreds of billions in other jurisdictions. And so as such, let's make sure we build them here. There's a few questions like, the use case specific regulation where I think there's a lot of agreement and, there's things we can just put in place that are pragmatic. And there are also a lot of still open questions. Nobody in the room was on the panel, but probably also in the audience can answer about, what's now happening with the new AI models and how that actually is regulated. So I think all we can do is talk about it, understand the technology really well, and then consequently come up with regulation as we go. Because I think there will be a lot happening we can't even imagine yet. I think many people in the NLP, NLU community couldn't imagine 5 or 10 years ago what happened, what has happened in the last couple of months. So it's hard to foresee. There will be, I think, a lot of things happening that will have a huge impact on humanity as a whole. But I think, nobody knows now. So let's just monitor glory and then adapt and have a regulatory framework that is flexible. I think that's also one of my biggest concerns, that as you see now, the speed with the EU on what they're doing on the AI Act, it's so slow. And this lawmaking process will just never be able to keep up with the technology, how it's progressing.
Thanks. Yeah, those are all very valid concerns. I'd like to share just 2 thoughts at the end very quickly. We started off with a couple of examples, right, of why we thought maybe AI liability regulation is a worthwhile topic at least to discuss. We thought about crashes in Tesla autonomous vehicles, and we also mentioned the GPT case in which a user was induced, or at least, there was a contribution towards suicide of this person in Belgium. It turns out, I just read that this specific model was not ChatGPT. It was actually a different model that did not have any guardrails concerning content moderation, which is why it pushed that person even further and suggested ways of committing suicide, which is something that with decent content moderation, and I haven't checked that, but I suspect, ChatGPT would not do this. And if you have decent content moderation in place, GPT-4, that should not happen. And in fact, that's a simple way, of making sure that these grave harms do not occur. I think one of the major focuses with generative AI is going to be content moderation. Not if we have performance that's 60 or 70% of accuracy, F1 score or whatever, we can all discuss this. But the big topics for our society, I think, are fake news, hate speech, and inducement to harm. And that's what we need to grapple with. And on the regulatory stage, that means that we need to update the DSA, the Digital Services Act. And it also means, because we're never going to be able to, and I fully agree with Rasmus, we're never going to be able to keep up with the regulatory, with the technological advancement. We need to build a structure, an architecture that enables us to be fast. And this could be, some principles, and then more fine-tuned safe harbors that can be adapted in a fast way without the European Parliament having to discuss all these things all the time again. And these safe harbors that could be rather technical would also provide some, safe haven for researchers, for developers. But if you leave them, you do so at your own risk. And I think that's a fair bargain that we could strike as a society. Of course, there are still many questions that are open. So I guess one of the takeaways from this panel is also that we need to be very use case specific. So maybe in the future, we need to have a panel on medical and a separate one on, autonomous and vehicles, and a separate one on generative AI. So I'm looking forward to more discussions within the AI for Good series. If that hasn't been enough for you, you're kindly invited to join the Neural Network, the ITU platform, for further debate and discussion on this topic. At this point in time, let me just thank all of the experts involved here, Wojciech, Rasmus in Berlin, and Joe in the US. Thanks so much for joining. I'm Philipp. It was a pleasure to be here. Thanks to the audience for excellent questions. Take care. Bye-bye.
Thank you for participating in today's AI for Good session. We hope you've learned something new, innovative, and engaging in today's event. We now encourage you to continue the conversation on the live video wall in the neural network. Here you can ask questions, like and comment, share links, complete the poll, connect with interesting profiles, or speak one-on-one using the chat and video function. We invite you to explore the lobby, try the smart matching quiz, visit the virtual exhibits, poster boards, the eShop, and build your personalized AI for Good program. Let's shape the future of AI for Good.
AI is a powerful tool.
This summit can help ensure that artificial intelligence charts a course that benefits humanity and bolsters our shared values.